Hello. Happy Thursday, everyone. I am going to give you all a few minutes to get in here. Thank you for tuning in. Today, I am going to be talking about 7 things that you need to know before you go to family court. I'm going to give people a few minutes to get in here. In the meantime, if you are tuned in, let me know where you're tuning in from in the chat box. Oh, let me turn my camera around on Instagram. I guess that would help. Hi, Instagram. So for those of you who have not watched me live yet, I am on Facebook here. I am on Instagram here. So if I'm looking at 2 different screens, know that I'm paying attention to both. Hey, Naja, I see you on IG. Hello, Malcolm. Hello, Mr. Cove. I can't see the name. Hi, you see Mo. Thank you for tuning in. Illinois, what's good? Los Angeles, you in my space. That's where I'm at. Thank you all for tuning in. And it's been a week. So, hey, do work. What's going on? Thank you all for tuning in. So I'm going to take a couple of minutes to introduce myself in case any of you are new around here. And then we're going to jump right in literally like 2.5, 3 minutes. So stay locked in while I introduce myself if you already know me. For those of you who don't know me or who are new, my name is Merissa V. Grayson. I am a child custody and family law attorney in the Los Angeles area, and I am also known as America's Blended Family Expert, a name that I have not chosen myself, but I have been called due to all of the work that I do in the family law and family court community. I am the founder of Family Court Academy, which is a program that I teach people how to represent themselves in court without a lawyer, but like a lawyer. So if you are in a family court case right now, if you are dealing with family law, blended family, co-parenting drama, you're in the right space. I hope that you came with your questions, and I'll be answering those throughout this live and at the end. And yeah, so again, thank you all for tuning in. If you have any questions, go ahead and type them in your chat box on IG. You can hit the little question mark. If you're on Facebook or YouTube, just drop it in the comments. I believe I can see all the comments as they're coming through. And we'll just go ahead and jump in. So today I want to talk about 7 things that you need to know before you go to family court. Some of you may have been on my live last week where I talked about 10 mistakes to avoid in your family court case. Today, I just want to talk about some things that you should know before you go to family court, whether it is your first time going to family court or whether it is your millionth time and you feel like every single time that you walk into the courtroom, it's a struggle, right? So, yes, this will be recorded. I'll leave the replay up probably for a couple of days. I usually take them down after that and throw them into Family Court Academy. So they'll be available there later on. But anyways, so yes, thank you for tuning in, Mr. Carter. And okay, so we're going to talk about 7 things I think that you should know. And one of the reasons I like to talk about this subject is because the family court system is so just daunting generally. It is very, if you aren't familiar with family law, if you aren't there consistently, then you probably may feel overwhelmed when you walk into the family court. So I like to give different tips on what to expect. Obviously, I'm in California. What you expect in Atlanta or New York or Chicago or whatever might be a little bit different, right? But ultimately, the same premises apply, the same rules apply. There might be specific nuances that you need to look up, specific laws and codes and things of that nature. But the overall things that you need to be mindful of when we're talking about going to a family court hearing, going through a child custody battle, a divorce, are essentially the same across the board. So let's jump in. The first thing that I like people to understand about family court is that courtrooms are scary for a lot of people, and oftentimes even for lawyers, right? So even in situations where I've known attorneys who have been practicing for years. They've been doing, some attorneys have even been doing family law for years, right? And they just get really, really anxious when it comes to representing people in court, because it is, again, it's a scary place if it's just not your zone, right? And when you're going through a court battle, it's not necessarily going to be your zone, because who wants to be in family court, right? So just understand, walking in, you're not going to feel like, oh, I'm so happy to be here. No matter how prepared you are, no matter how much work you've done. And even if you're walking in with a lawyer, you still might feel like it's overwhelmed. So a lot of times I tell people that, even other attorneys, right? Like, I do family law, I do some business law and entertainment law as well. But for the most part, when people find out that I do family law, oftentimes other lawyers will ask me, man, how do you do family law? How are you going into family court? Man, I can't imagine having to deal with that, right? So these are people who have gone through law school, who have passed the bar exam, who have done all of this work to be advocates for people, and they still feel uneasy. So if you feel a way about going in there, I just want you to know that that is part of the process, and that's a normal and, reasonable feeling. So that's the first thing I want you to understand. The second thing, I talked about it last week. I'm going to repeat it probably a million times, because it's something that a lot of people struggle with, and that's remembering that all cases are not created equal, right? Your case is not equal to your friend's case, your cousin's case, your aunt's case, or even the case that you just watched 5 minutes ago if you were tuned into a family court case. Every single case has different facts, different circumstances, and you can't assume that things are going to go the same way that they went in someone else's case. So always just be mindful that when you're handling your case, you need to be handling it on an individual basis, not based on something you saw on television, not based on something you heard from somebody that you know, and just plan and prepare accordingly, because your case is unique. And just because someone else lost custody, for example, that doesn't mean you're going to lose custody, right? Just because someone else made a misstep or a mistake, or because they've been an absent parent for 8 years, and when they tried to get some visitation or custody, they were denied, doesn't mean that that's going to be the situation in your case. Every state has different laws. Every state has different rules, procedures. And though overwhelmingly, again, the process is similar in the majority of the states, nothing is going to be exactly the same. So keep that in mind. Number 3, before I jump into number 3, you guys make sure you comment your questions by hitting the question mark. Drop them in the comments section. And if you know anybody who needs this information, just please make sure that you go ahead and click the share button so that they can tune in as well. All right, so number 3. Number 3 is all judges are not created equal. Now, this goes along with number 2, obviously, but a lot of people are surprised to feel like when they left a courtroom, they feel like there was a bias against them. They feel like the judge may not have liked them. They feel like the judge, had an attitude with them or treated them differently, or, well, the other person who came into, a different courtroom, they got a particular order, and now I'm asking for the same thing and mine was denied. So again, they go hand in hand, right? But again, judges are humans just like everybody else. They wake up, one day they might have a good day, one day they might not, right? One day they might feel like being a little bit more flexible or being a little bit more helpful because you don't have a lawyer, or giving you a little more grace. And the next day they might be like, the rule is you got to follow the procedure, right? So just understand, again, no judge is the same, no case is the same, no courtroom's the same. And I talked about this last week, but you also got to keep in mind that if it's possible for you to go ahead and tune in to a court case or to sit into a courtroom, I know we're in COVID right now, and you can sit and observe the judges. That's a good way to get to know them. Read the reviews about them ahead of time if you can find some, because it's a little difficult depending on what state or county you're in. But just try to get as much information that you can as possible about the judge that you're going to be in front of, so that you can have an idea of the things that you might need to tweak. And I even do this as a family law attorney. I mean, in LA, I pretty much am familiar with the majority of the courtrooms and the judges here, so I don't have to do it as much. But specifically, when I was a newer attorney, I would go and I would sit in the courtrooms and just watch the cases, because a lot of the cases and proceedings are public, right? So I would go, I would sit, I would watch, I would listen, I would take notes, I would pay attention to the judge's demeanor, their process, their court staff, all of that stuff I was mindful of and paid attention to. So that was number 3. Number 4 is really, really important. And this is where I feel like a lot of people misstep. It's knowing what your case is about. So, for example, a lot of times you might get served with some documentation, or you might get notice of a hearing, and you think you're going to court for one thing, and then you get there and it's a completely different issue. So you've prepared your arguments, or you've got your documents and your evidence, and you think you're ready, and then you get there and the judge is like, that's not what we're talking about today, right? A lot of times people come to me and say, well, I tried to tell the judge X, Y, and Z, but they wouldn't listen. They said that's not what we were there for. That's not what was on calendar, that they didn't have that issue before them. And that's because when you reserve a court date, or when a date is assigned to you, essentially it's because someone has filed something, right? So when someone files a document requesting that the court have a hearing, essentially, right? Whether it's a motion, a request for order, or whatever it's called in your state. When someone files that document, they raise issues in those documents. For example, if I want custody and visitation orders because we don't have any, then I'm going to file a request or a motion for custody and visitation orders. We show up at that hearing. I can't then say, if I didn't include it in my initial paperwork, I can't then start making arguments about child support and how the other parent never supports me and doesn't provide me with any money to take care of the kids or anything like that. If you want the court to consider those things, you have to make sure that that's included in your paperwork that you're initially filing, right? That's if you're the filing party. If you're the person who is responding, same principle. If you're responding to some documents that the other parent filed, then respond to those documents. But remember, you're only responding to the issues that were raised. So, for example, if someone files a request for child support and you want to have visitation with your kids, but that's not raised in the initial paperwork that you're responding to, then what you need to do is you'll have to file your own set of paperwork, whatever that document is called in your state, saying, I also want the court to talk about custody, visitation, custody exchanges, whatever the concerns are, school choice, whatever it is. You have to file your own request or motion and get your own hearing date. Sometimes they might set it for the same date that you already have for the other person's paperwork, and then sometimes they might give you a completely different date. I hope that makes sense. Is that making sense? If it makes sense, put a thumbs up or something in the comments. If you need me to elaborate, let me know that as well. So that's number 4, just always knowing what your case is about. Read the paperwork when you get it, right? When you get it, read through it, make a note of the issues and the things that have been raised, and prepare to write your response accordingly. And if it's something that you want to talk about that's not in there, then you need to file your own documents. Okay, that moves on to number 5, which is preparation is key. Prepare for your hearing. And whether that is reaching out to an attorney in your area so that you can get a consultation. Listen, I get that attorneys are expensive. You may not be or may not want to hire an attorney to represent you for your case, right? That's completely your choice. Totally up to you. If you can hire a lawyer, a good lawyer, keyword, and that's a conversation that I'll save for another day. But if you can hire a good lawyer to represent you, then cool, do that. If you cannot, I always say it's a good idea for you to try to consult with an attorney. Consultations usually require a consultation fee. That's FYI. Most attorneys charge consultation fees, right? You have some attorneys that do free consultations. And I'll just tell you now, a lot of those free consultations are not really consultations where they'll actually guide you through your case, tell you what to do, tell you how to represent yourself. Sometimes, not all, but a lot of the times, those free consultations are really just phone calls for you to have with the lawyer tell them about your problem, the lawyer to be able to tell you whether they can solve your problem or help you with your problem. And then they'll tell you how much it's going to cost, right? So if you're looking for some guidance, like real guidance on your case, if you need step-by-step, okay, this is what you need to file. This is how you serve. This is how you do this. These are the types of things that you should say or think of when you're in your hearing, then you might want to pay for a consultation with a family law attorney that's experienced with dealing with issues that you're facing. So that's just, a note on consultations. Another way to prepare, if you can't afford or choose not to consult with a lawyer, Google is your friend, right? I'd rather you Google and do research and find articles from lawyers than not do anything and show up and say, oh, but I didn't know, or I didn't understand, right? I don't even know how many articles and videos online. I have a YouTube channel. Some of you are tuned in on YouTube. And I post videos. A lot of attorneys post videos. A lot of attorneys write articles. They give family code sections that you need to be aware of. They talk about the different laws in your state. So if you are looking for information on the cases that you can use as examples when you're making your arguments, if you're looking for your child custody or divorce laws or whatever in your state, literally, if you have nothing else to do that you can do, then just Google child custody laws in Texas. I promise you something valuable is going to come up from somewhere. So you'd rather start there and have that than, again, walk in not knowing anything. So that's just another thing to be mindful of. Number 6 is, if you have a hearing that comes up, if you're served with papers specifically, request more time if you need to. And a lot of times people get their paperwork and then they scramble to try to make it into court and to get ready for the hearing, and they're not ready, right? They had no idea. They didn't have time. They couldn't come up with the money to get a consultation. So they kind of just rush in blindly and then they try to wing it through, right? If you don't have to do that, then don't do that. So if you get paperwork and you're served and you have a court date coming up and it's not that much time, look up the rules in your court, your local court, wherever the hearing is being held. Look that up and find out, even if you have to call the clerk. Every courthouse has a clerk's office, right? Whether it's the family court, any other court, you can find a, find the numbers to the courthouse, to the courtroom, whichever you need to do. Call and say, how do I get a continuance in my case? I'm not going to be ready by the time the hearing date comes. Attorneys request continuances all the time. If I get onto a new case and there's a date coming up and I need more time, I request time. So it's not unreasonable, and don't feel like you're doing something out of the norm if you're asking for more time to prepare. If you can't get in contact with someone, prior to that, do all the research that you can, consult with a lawyer if you can. And then if you still feel you aren't ready, show up with what you have, prepare as much as possible as if a continuance is not going to be granted, but then you still request it when you get there. Some courts will require you to file a request for continuance formally prior to the hearing date. So as long as you look up those rules and figure out exactly, what the process is to get a continuance, you can do that and request more time. But at least make the effort. If you need more time, don't feel like you can't. At least try to get more time. Worst case scenario, you're going to be in the same position, which is rushing and scrambling, trying to figure it out anyways, right? So at minimum, if you need more time, start figuring out if getting more time is possible. And last but not least is, if you go to court, when you go to court, if things do not go your way, which more often than not, things are not going to go your way, right? When you have a judge who does not know you, they don't know your kids, they don't know your family, they don't know what you need, they don't know what your kids need. When you have a judge that's going to make a decision for you, 9 times out of 10, neither party is going to walk away 100% happy. So understand that if things don't go your way, don't panic. Don't go crazy. Don't, decide that you're not going to follow the orders. Don't decide to start making things more and more difficult. You have to take a moment, sit back, reflect on what happened, look at the reasons that the court gave for issuing the orders that they gave, figure out if there's something that was missed or a mistake that you can overcome. or figure out the process to ask the court to reconsider whatever decision it was that they made. And then later, or what you need to do in the meantime so that you can ultimately get to the result that you desire. So for example, if you're a parent, a lot of times I have dads in particular who come to me who have not had time with their kids for a long time for various reasons. So they may not have seen their kids, 2 years, 3 years, 8 years. I had one client who had not seen his kid in 10 years. The kid was like 14. For whatever reason, there was a lapse in time. And when they went to court, the judge said, okay, I'm going to give you some visitation, but I'm not giving you much because you haven't proven that you really want to be in your child's life. So they gave that client, I think, maybe a couple of hours, maybe once or twice a week. And that client was so upset. Like, I need more time. I already missed out on so much time. And, be patient, just follow the orders. Enjoy the time that you have. We can work up to the time that you're trying to get to, right? So a year of this order that he didn't like, right, passes, and then we go back to court. And then ultimately, at the end of the day, the kid wanted to go and live with him, and that request was granted, right? So he missed out on that time, spent that year doing the makeup time, essentially, that he was not comfortable with and didn't feel like was enough. And then after that, the child got to spend the last 4 years or 5 years of the child's childhood with him. And then they had a great relationship. And now, obviously, the kid, well, not obviously, but the kid is now an adult and their relationship is still good. So all is not lost if things don't go your way. So I just don't want you to feel like you have to give up, if things are not going the way that you expected or the way that you have wanted. So those are my 7 tips. Understand the courtrooms are scary, even for lawyers. That's a normal feeling. Number 2, all cases are not created equal. Number 3, all judges are not created equal. Number 4, make sure you know what your court hearing and your case is actually about. Number 5, preparation is key. Failure to plan, you're planning to fail. I know y'all have heard that before. It's true. So prepare as much as you can with what you have. Seek out resources and help if you can. Number 6, request more time if you need it. Find out what's required to get a continuance in your state. And number 7 is, if things don't go your way, don't panic. All right, I'm going to get into these questions really quick. If you have any questions, now's the time to drop them in if you have not already put them in the comment section. So I have a question on Instagram from UC Mo. If you initially filed already and the court date hasn't came yet, but another issue happened in between the time you filed, I'm going to assume that the question, I can't see the rest of the question, but if you file something and then something else happens, most courts probably have some type of process where you can file a supplemental document of some sort, like a supplemental declaration or a supplemental statement that lets the court know what's happened since the documents were filed. So you will want to contact the clerk's office or look up the rules of civil procedure in your area and the local family court rules in your area. And that should tell you what the timeline is that you have to file the documents by. So always know what your deadlines are. That's one of the main rules that you need to be aware of. You oftentimes will not get a pass if you don't know those rules. So in most states, there's a rule of civil procedure. There are family codes, and then those two are usually the different types of laws that apply. So the rules of civil procedure, are usually where you find out the process and the deadlines, the timelines, and things like that that's required. So I hope that answered your question. All right, let me go over here to these YouTube/Facebook comments. Now, I saw some YouTube comments. My YouTube family, y'all be wilding out. I say this all the time. Don't make me have to block you. Hopefully everybody is in good energy today. Okay. I'm going to show this comment, which says, what can a parent, hold on. It says, what can a parent do if the other parent wants to move the child to another state to avoid Current contempt of court charges. So if there are already court orders in place and the other parent wants to move, and essentially anytime a parent wants to move out of state after there are already court orders in place, there's a process that has to be followed in order for you to move. You can't just, once the court is involved in your case, you don't really have the freedom that you had before you opened the case, which is oftentimes specifically for the parents who don't have custody, right? Or the parents who didn't have the kid in their care. That's the reason that you want to file to open your case, because you don't want somebody just taking your kid and leaving because there's no order prohibiting them from doing so. So if there's an order in place, they have to follow the process. There's usually a request or a motion to move away that must be filed in order for the court to make a decision related to them moving. Some states do give a parent the right to move, but they still usually have to notify the court and seek permission from the other parent or the court. So you want to look up move away laws in your state, whatever state that is. So for me, it would be move away laws, California, child custody, right? Google that. Pretty sure some articles will come up. You'll probably get some cases. So yeah, if they want to move to avoid whatever the reason is, when a parent wants to move out of state, if you're trying to take the kid and you have a shared custody plan, or if the other parent has visitation, the court typically will require you show different things. Like they have these different factors that they consider before they make the determination. So why are you moving, right? Is that move in the child's best interest? All of these things are things that the court often will consider or require the other parent to prove before they actually can up and leave with the child. So if they're trying to leave, you can also probably file a request or a motion to stop them from leaving if they've already indicated that their intent is to leave. So look up the move away laws, and hopefully you can follow the steps to make sure that that doesn't happen if you're not in agreement. Okay, let's see. What state am I in? I am in California, Los Angeles area to be exact. Let's see here. Okay. Y'all be getting crazy in these comments, so I'm going to just skip over. You know what I don't like? Let me just tell y'all since you're here. If you own my YouTube channel, I appreciate you being here and being there. But when people come to my channel literally to get help and tips and information on how to improve their child custody situations, right? We don't need y'all all up in the comments talking about what's not possible. The family court system don't like you. The system isn't built for us. You know, we can never win. I get all of that. I get the feelings. I understand they're legitimate, but don't bring your bad energy up in here. Like, people are here because they're trying to learn. If you ain't trying to learn, that's cool. Like, that's good. Keep scrolling. But you don't have to come fuel the fires. People are already struggling, trying to see their kids, trying to make sure that they can build relationships and find their kids. And, you know, so anyways, that's just my random vent because I'm scrolling through the foolishness right now. Okay, let's see here. It is, let me see. Tanisha said, is it a good idea to settle before the evidentiary hearing? Because I hear a lot of times people end up back in court anyways for the same issues. Is it good to just proceed and get it all out on the table the first time? I actually like that question. That's a really good question. So here's my thought. It's always better for you to settle if possible. One, it minimizes the conflict between you and the other parent. Two, as I mentioned before, when it comes to these judges, you don't know what you're going to get, right? So you might want 5 days a week of custody, and the other party might be trying to compromise at 3 or 4 days a week, and you going to the judge, chances of you getting that 5 days are kind of like you taking a risk, right? So you want to make sure that you are putting yourself in a position, because now, one, you're going to the judge, you're going to spend more money. You're going to spend more time because you got to wait on the hearing date. And then you're gambling. It's like rolling the dice. You don't know what's going to pop up, right? You're pulling from the deck. You don't know which card is going to come up. So if it's possible to settle, Absolutely. I would say settle, because you'll end up more often than not in a better position than you would have been in if you had to actually go to court. Not to mention, the evidentiary hearing process is not a fun one. Having to get up there on the witness stand, be questioned by lawyers, be questioned by the judge, people questioning your credibility, asking all your personal business, putting your documents in the public record, all of that stuff. If you can avoid it, it's a good idea to avoid it. Additionally, like I said before, it can minimize the tension between you and the other parent, because even if you aren't able to agree 100% on everything, if you can kind of meet in the middle and compromise, that's the first step to getting to where, you're trying to go. Now, I'm not going to say be bullied by the other party or the other party's lawyer into signing something that you're 100% uncomfortable with or know is not going to be in your child's best interest, right? But fighting over things, and this goes back to last week, I talked about making sure you pick your battles and knowing what's war worthy and what's not, right? If you're going to go to trial over one day a month, it's really not that deep, right? Like it's really not. People do it though. People go to trial over who's going to drive the child to soccer practice. Who cares who drives the child as long as he or she gets there, right? But some people, because they don't have that ability to set the egos and the emotions and the frustrations aside to make those decisions and say, you know what, you want to drive in practice? Cool. Go ahead and do that. Right? So just, you have to know what is the most important to you. And as long as it's not one of those most important situations that you feel are non-negotiables, I always advise clients to try their best to settle, because it just sets a different tone for your co-parenting relationship and your ability to move forward. All right. Let me see here. Someone said, you're not going to win in family law court fighting fair. We can agree to disagree on that. You can fight fair and still be assertive and still, handle your business. I do it all the time. So yeah. Anyway, let's see. Question. Should criminal allegations, which are child abuse, domestic violence, etc., be adjudicated in criminal court where rules apply? Yes, they should. They are typically, depending on the state, adjudicated in both. Oftentimes, if one is charged with domestic violence, child abuse, they'll have a dependency. I think that's what they call it in most states, dependency court. You might handle in family court, and then it also may result in criminal charges. So if you get a family law, domestic violence restraining order, if the police were called or any third parties like the Department of Children and Family Services, Child Protective Services, whatever it's called in your state, if they're involved, then they might refer it to the district attorney's office or an investigator at the sheriff or the police department, and then it'll turn into something completely different. So I guess it really just depends on your state and your area, but yeah. What are the rules for the continuance time again? It's the continuance times are going to depend on your state and where you're located. So you just want to contact the court, your local court, wherever your case is held, if you need to request a continuance, and find out how to get a continuance. And sometimes you can just call the clerk and say, hey, I have a hearing on calendar for June 3rd. I, just received the documents. I need time to prepare. How can I request a continuance? Sometimes they'll just tell you. Sometimes they'll direct you to a self-help center that's located in the courthouse or at a legal aid foundation, but they'll usually at least point you in the right direction. Again, Google is your friend. Google might tell you as well. I found some answers for people in states that I don't practice in, just by, looking it up for them. So you just got to be a little creative, but at, worst case scenario, try calling the clerk's office. That's what they're there for. They manage the courtrooms, they manage the courthouse, and oftentimes they can, point you in the right direction. They won't give you legal advice, but they can point you in the direction you want to go. All right, let's see. Ashley says, can you file for full custody if the non-custodial parent is paying child support but wants nothing to do with the child. Yes, you can, generally. So if there are already orders in place, if they have not been following their visitation orders, then you usually can request to modify the orders, and that person has the right to notice so that they can defend themselves and object to your request if they want to. But typically, you know, either party can file for custody in most states. And I know that people say and believe that the court system, you know, fathers never win, mothers are always right. That's not the case all the time, you know. So don't think that just because you're a dad that you can't get custody, or that you're a mom that you absolutely will, because it can go either way. So, okay, I hope that answered your question, Ashley. Let's see. Jamar said, I'll be starting a fatherhood YouTube. Yes, do it. We need more information and knowledge out here. Let's see. What if the child wants to stay with the dad? Then dad has the option to file a request for the child to come and stay with them. You know, again, child custody is not necessarily determined by gender. And that's just a misconception. Oftentimes, moms do end up with custody. I'm not going to go into why I think that that's the case. But I will say, if you're a dad and the kid wants to come and live with you, it's not going to hurt you to try. Worst case scenario is they're going to get a no, right? So not trying is kind of pointless. So yeah, if your child wants to stay with you, you can ask the court to consider that. Depending on the age of the child, you can ask the court to let the child participate in the proceedings. Most states have a process that allows children to express their wishes to the court. Different courts have different policies as to how that can happen. However, it could be something like the child is appointed their own attorney, the child is interviewed, or they may do what's known as a custody evaluation. And that's where an independent psychologist or psychiatrist who is assigned by the court or approved by the court will do an evaluation, talk to the child, talk to the parents, learn about the family situation, and then make a recommendation to the court. So there are a couple of different ways that you can get it done. But again, you have to file the request. So I would look up child's wishes, child custody in whatever state you're in, see what comes up. And yeah. Okay, let's see what else we got. This thing keeps scrolling. I have not. Someone asked, have you seen the Divorce Corp documentary? No, I have not. And I'm not going to block you. It says, please don't block me. Can I represent clients in Orange County? Absolutely. I have a lot of clients in Orange County, Riverside County, San Bernardino County. Let's see. Oh, you said you called my office. Somebody called my office. Yeah, I'm pretty much everywhere in California. You know what? I appreciate this comment. It says she really is amazing, not like other lawyers. I appreciate that. You know, I get a lot of drama here on YouTube because I try to put y'all up on game, but some people think I'm a feminazi, or that I hate moms, or all kind of craziness. Like, I'm just trying to see everybody win and families move forward in a way that is going to be productive, right? Just because the parents aren't together anymore doesn't mean that y'all shouldn't be able to parent and the kids be good without having to go to counseling and therapy and all of this stuff because of the drama between the parents. So I appreciate that comment. Let's see. I think that might be it. Anybody got any more questions that I didn't answer? Oh, I got a couple on Instagram. Let's see. Are you able to send or post the chart you talked about in the last live? What chart was that? Yes, I'll post it. I just don't remember what it was. I know I talked about a co-parenting journal. Forgot to post that. So I will post that in the comments when I'm done. And I have a sheet. Maybe you're talking about a sheet. Let me know what sheet you're talking about or what chart. But I also have a chart where it has like the different states and links to the laws. The links might be old, but I'll upload that as well. If it's something else, let me know. And if I said I'll post it, I will post it. I probably just forgot. So please remind me. All right. Hi, Ari. Let's see. Even when a man decides to fight for custody, he will 9 times out of 10 get negative backlash. You can get backlash, right? You'll be all right. Just fight anyway. If you want your kids, backlash kind of comes with everything in life. We got to stop worrying about what other people think and do what's best for our kids. So let's see here. Can I reference any lawyers in New York? Yes, I can. My go-to New York attorney is Jolena Pickett Lewis. I will put her information in the chat box when we're done. I got custody of my child before. I know I can do it again. I believe that you can. All right. What else? What reforms would I recommend for family law? That's a whole nother live for a whole nother day. Because even though I work in the family court system, and I think this is where a lot of people get it twisted, I don't necessarily love it, right? Like, I don't love the way that the system moves. I don't like the way that orders are made in some states. So there are a bunch of different ways that I would change family law if I could, because I think that things should be a little more straightforward. But hey, I'm not a lawmaker, so I work with what I got and I try to change what I can, and I have some things in motion. But yeah, that's a whole nother conversation for another day. All right, what else we got here? Anybody else have any questions? Let me see. Okay. Oh, the journal to keep track of communication with the parents is what I said I was going to upload. Yes, I will put that. You know what? If you want that and you're on Instagram, TWN Mom 10, just shoot me a DM on the Family Court Academy page that you're on right now, and I'll just shoot me your email, and I'll make sure that you get that. If anyone else wants that, if you're on Facebook, I will go ahead and put that in the comment section. Let's see. Anyone else? Questions before we head out? No, nothing. Let me make sure I didn't miss anybody. Last week, people were inboxing saying I missed their questions. So want to make sure we're good. I'm going to try to go live same time next week. Not sure what the topic's going to be. If you want me to talk, next week I'm talking business law, but I might come in another day and talk about family law. But next week I'm talking about, for those of you, if you're an entrepreneur, I'm doing the need to know basics of business and branding, the legal basics. So we'll be talking about all things related to business formation, trademarks, copyrights, contracts, all of that. So if you're an entrepreneur, brand builder, entertainer, artist, make sure you tune in. You can find that link. It'll be on my Merissa V Grayson page or the Collective Legal page. All right. I don't think I have any more questions. Why? Oh, I do have one more question. Why is it so hard to get visitation enforced? I think that depends, but it could be a number of things, right? So if you want to see your child, if there are orders in place, there are a bunch of different ways that you can enforce your orders depending on the state that you're in. Most states have like a contempt proceeding of some sort, an enforcement proceeding of some sort. Some states, some counties allow law enforcement officers to jump in and show up at the parent's door who's not allowing the visits. Some states won't allow that, and some law enforcement officers will not fulfill that. So I think the difficulty with enforcing orders is really just a matter of what the process is, and knowing what the process is and following that process. A lot of people assume that, just because you have orders, it's just going to be, they have to follow it, and people, they don't follow them, right? If you're in California, then you can file a request for order for enforcement and request that the other parent be responsible to reimburse your attorney's fees. Family Code Section 271 is a code that allows you to request sanctions for violation of an order and otherwise frustrating the possibility of settlement. So you can file a request for enforcement of your custody and visitation orders. And there's also contempt proceedings if it's, if you wanted to go that route. But yeah, California, I enforce orders all the time. It's a little time consuming, but it can be done. And also in a lot of states, including California, if the other parent is not following their custody orders, there are code sections that say not following the orders will be or could potentially be a reason to change custody to the other parent. And that's one thing that, a lot of us have to remember. The job of the parent who has the child is to make sure that you are facilitating the relationship with the other parent, specifically if you're the parent that has the child with you the most. So, just make sure that you do that. All right. I have one more question. How do you prove emotional abuse? I see this video request. I'm gonna approve it. I'm assuming you're not a bot. So I'm gonna let you in here, and we're gonna pray that it ain't nothing crazy. For those of you on Instagram, on Facebook, you probably can't see it, but let's see. Can you get on here? Someone's requesting to be on my Instagram to ask a question. For some reason, the feature is not letting me bring you on here. So the question was, how do you prove emotional abuse? Whew, that's a whole nother video. I'll say start with getting your child in therapy, or getting yourself in therapy, but getting your child in therapy. If we're talking about emotional abuse of a child, having your child, depending on the age, participate in the proceedings somehow, having them appointed their own attorney to represent their best interests. There are a lot of ways that you can prove it, but approving abuse that's not physical is, again, it's a process, but it's possible. So you just have to make sure, one of the key things is making sure there's a neutral third party in the mix who can substantiate the claims that are being made. So if there's a claim or an allegation that there's emotional abuse going on, the best way is to have a third party. And if you don't already have third parties involved, then you might want to, request that a third party be appointed, whether that's a guardian ad litem, depending on what state you're in, an attorney to represent your kid, a child interview, a therapist, things of that nature. Okay. Finally, someone says, Merissa, I pray I never get to call you or any other lawyer. I pray you don't have to call me either. Listen, I do not want to increase my roster. I prefer that everybody be able to co-parent and blend and everything else without all the drama, if possible. So, best of luck to you. I hope that you don't ever need to call me, but if you do, make sure you call me. All right. I think that's everybody. I think that's all the questions. So thank you very much for all of you who have tuned in. Again, I'm Merissa V. Grayson. You can find me all over the internet. I am at Merissa V. Grayson. It's Merissa, V as in Victor, Grayson, Grayson. If you found this video helpful, please drop an emoji in the comments. Please share this video with someone who can use the information. And please just make sure that you let me know if there's a topic that you want me to help you with. Someone said your videos helped me in court. See, this is what I mean. This is why I do what I do. And I've had people inbox me and tell me, oh, I listened to your video and I got custody of my kid. I hadn't seen my kid in X amount of time, and now I get to see them. Like, even if you don't have a lawyer, and that's the reason why I do the videos and I do the lives, because I know everybody doesn't have a lawyer, and everybody doesn't have a lawyer as dope as me. No, I'm just playing, kind of, not really. But anyways, so yeah, you know, there's free information out there. I'm here. My channel, if you have not already tuned into my YouTube, I'm Merissa V. Grayson on YouTube. I'm on Facebook, Instagram, also Instagram, Family Court Academy. There's tons of information out there. I have a bunch of information on my websites. So use what you can, use the resources that you can. And thank you all for being here, for tuning in. And I'll see y'all next week. I will post when I'm going live next week on family law. If you're interested in the business law topic, make sure you're following Merissa V. Grayson. I think I'm going live Thursday for that one, but I have to check. So anyways, thank you for tuning in, and I will see you all next time.